in this particular discussion, we'll be having certain points of discussion where we'll discuss about the three pillars of our Indian Constitution. Then we'll discuss about the amendments in Article 368, followed by its seventh schedule and scope of judicial review. We'll talk about the basic structure. Last but not the least, we'll talk about the landmark judgments related to it. Followed by, if anybody would be having question, we'll take that in the end of the session. So today, as a guest speaker and to throw the light on this particular topic, we have with us Mr. Nitesh Ranjan. He is a managing partner, Navagraha Company, Advocates and Solicitors. So I welcome you, sir, for this session. Sir, you're not audible. 1 second. Hello.
Am I audible now?
Yes, sir. Now you're audible.
Okay.
Yes, sir. So I welcome you for this session.
Okay, thank you. Thanks a lot.
Right. So before we start our session today, let me just introduce our today's expert, our come speaker. Our Mr. Nitesh Ranjan sir has completed his graduation from KIT Bhubaneswar. Later, he worked as in the chamber of Shri Ardhendumoli Kumar Prasad and assigned him for 5 years. He appeared in many reported landmark judgments delivered by Supreme Court of India. Some of the case I am going to recite. Some of the cases are Nipun Saxena versus Union of India, 2019. This is recent case. Indra Jaising versus Supreme Court of India. T.N. Raghupati versus High Court of Karnataka. He is currently a member of Supreme Court Bar Association and is founding partner of Navagraha Company. So we have a lot to learn from you, sir. And without any further ado, now I will request you to please take over this webinar.
Thank you.
Over
Thank
to you,
you.
sir.
Good afternoon, all. This is my first session. This is my first webinar, rather I can say, where I am addressing students. Till time, I was addressed by my professors, and when I was working with Mr. Ardhendumoli Kumar Prasad, he used to teach me how you have to learn the basic principles of law, and a senior is always a senior. So whatever today I am is due to my professor Kumar Kartike Tiwari. He is now not in this world, but he was a very great professor. He taught us constitutional law in my law college in KIT. So whatever I am delivering today is taught to me by Kumar Kartike Tiwari. Without wasting time, I am coming to the topic, Judiciary, the true custodian of Indian Constitution. Why I have decided to give a lecture, not lecture, to share my knowledge about this topic, because in contemporary situation, in situation where we are living right now, there is a war going between judiciary, executive, and legislature. Day by day, every day we can see that there is a tussle between parliament and the judiciary. Most of us now are on social media, so we are better. So we have better knowledge about Indian politics in comparison to those persons who are living in 1970s or 1980s. So before starting my lecture and the introduction what I had given about myself, I want to go back in 1950. 1950, the time after independence, our constitution came into force on 26th of January 1950. It was enacted on 26th of November 1949, but it came into force on 26th January 1950. What happened after what happened after constitution came into force? As our country is a very big country with a lot of diversities, people were poor. We didn't have so much resources to exhaust. So at that time there was Jamindari Pratha. Jamindari Pratha was there. So what we were required, because we were a country which we were a country where the most of the people were depending on agricultural land and agriculture. But agricultural land was the best thing which the government can give to their citizen for the purpose of occupation. But because most of the lands were under control of jamindar, under the lands were registered on the name of jamindar, so the problem arises. The problem arises because of right to property. Right to property was a fundamental right, and no one can take fundamental right from you. So the government came with first and fourth amendment, through which the government wants to change the status of right to property from fundamental right to legal right. Now here the problem arises. The government has a very good motive to suffice their citizen, to provide their citizen with those things which can help in their occupation. But what the government did, the government came with a ninth schedule. Now the ninth schedule, what the ninth schedule was exactly? Ninth schedule, what the government did, the government said that whatever we can put in ninth schedule, no court can no court can make review of it. No court can see what are the government are trying to insert in ninth schedule will not comes under the purview of judicial review. So here the problem arises. First case of Sankari Prasad versus State of Bihar, 1951. The Supreme Court has decided in Sankari Prasad versus State of Bihar. Now in Sankari Prasad versus one thing I want to clarify, that this is pre-era of Kesavananda Bharti case. So there are three cases which was most importantly dealt by me in this webinar while deciding about telling you guys about the situation pre-Kesavananda Bharti situation. What happened in Sankari Prasad Dev versus Union of India? The Supreme Court held, the whole tussle was about the law, an ordinary law and a constitutional law. Before going into detail of Sankari Prasad, I just want to tell one thing. Decision in any constitutional cases are different from decision in normal cases, because in normal cases what happened, the law is propounded on the basis of legal history, but in constitutional cases not only the legal history can be seen, the judges can also see the adversity of time. So in Sankari Prasad the same was applied. In Sankari Prasad, the Honorable Supreme Court held that law must ordinarily include constitutional law, but the court built a clear wall of demarcation between ordinary law, which is made in the exercise of legislative power, and constitutional law, which is made in the exercise of constitutional power. Now, what is the thing which I want to elaborate? In Article 13, Article 13, law must be taken to mean rules or regulation made in exercise of ordinary legislative power, and not amendments to the constitution made in the exercise of constitutional power, with the result that Article 13 clause 2 does not affect amendments made under Article 368. Here the problem arises. Article 13.2 gives power to Parliament to enact any law in regard to fundamental right. But what the Article 368 says, Article 368 gives constituent power to the Parliament, which could not only be used by the Parliament to bring reforms in the Constitution, but it could also be used for enact the Constitution as a whole. Hello, am I audible?
Yes, sir, you're audible.
Okay, thank you.
I'll
Now,
I'll inform you if you're not, if will not be audible. I'll
okay,
inform.
thank you,
Right,
thank
sir.
you. So Sankari Prasad makes a clear demarcation between law made under Article 360 under 13, Article 13, and uh, law made under Article 13 Clause 2 and Article 368. Now, what happened in 1955, around 1955, the uh, the government of India came with another amendment, the 17th Amendment. This is also relating to land reforms. Now, agreed by this land reform 17th Amendment, which were taking rights of fundamental right of a person of right to property. Sajjan Singh, a guy named Sajjan Singh, filed a writ in the Supreme Court as Sajjan Singh versus State of Rajasthan. In Sajjan Singh versus State of Rajasthan, certain provisions of the 17th Amendment Act were challenged on the ground that it introduced a change in Article 31 in Part 3 of the Indian Constitution. Article 31 in Part 3 of the Indian Constitution thus was in direct relation with Article 226. And as a result, this amendment indirectly amended the Article 226. Therefore, it has not been passed in accordance with the procedure given thereof in Article 368. The Honorable Supreme Court stated that amending the fundamental rights will not affect the Article 226, and procedure is laid in Article 368 is followed. This pronouncement clearly substantiates the proposition that in the absence of an express text or provisions, we cannot restrict or negate the power of the legislature. Now, what happened after this judgment? This judgment clearly established the supremacy of the parliament in order to amend the constitution. Now, after Sajjan Singh, the things were changed. Now the government had been provided with a lot of power to amend the constitution as whatever way they want. Now, after this in 1962, IC Golaknath versus State of Punjab, a landmark judgment where Subba Rao had given the majority opinion. Now Subba Rao, by way of IC Golaknath versus State of Punjab, tried to control the damage. The damages which were caused due to the judgment of Sajjan Singh versus State of Rajasthan. The Honorable Supreme Court, while delivering this judgment, came to the conclusion that the power of the parliament to amend the constitution is derived from Article 245, 246 and 248 of the constitution, and not from Article 368, thereof which only deals with procedure. Amendment is a legislative process. Now what happened here? The Subba Rao in majority, Justice Subba Rao has said that Article 360, the procedure is laid down in Article 368, but the power came from 245, 246 and 248 of the constitution. And while restricting the government from making laws or making amendment, Subba Rao also did a great mistake. Amendment is law within the meaning of Article 13 of the constitution, and therefore if it takes away or abuses the right conferred by part 3 thereof, is void. This was also delivered by Subba Rao. So Justice Subba Rao further concluded that the Constitution First Amendment Act 1951, Fourth Amendment Act 1955 and the 17th Amendment Act 1964 abridged the scope of the fundamental rights, but on the basis of earlier decisions of this court, they were valid. On one side, the Supreme Court by his Chief Justice Justice Subba Rao restricts the government from making law regarding the land reforms, but held that the amendments which by virtue of which the fundamental right, the right to property, which was initially a fundamental right but now a legal right, held that valid, held that the legal right, article right.
Sir, you are not audible.
So due to all these due to all these things and the Land Reforms Act and the 9th schedule which were propagated by uh, the government at that time, Keshav Nanda Bharti versus State of Kerala, a very landmark case. The judgment was delivered by 7:6. And one thing which I want to say, that the power of amendment, the power of amendment which lies with the government, with the parliament, is not an absolute power. The war which I want to deliver here, the war which I want to deliver here between the judiciary and between the parliament and the judiciary is this only. The parliament wants to have an absolute power to amend the constitution from wherever they want in the constitution. But the Keshav Nanda says that there are something which is basics, which are the basic of any constitution. So you can change, but you can't change it in a manner that can change the whole idea of the constitution. The Honorable Court said, amend as you may this constitution, because you know best the needs of your generation. But the constitution is a precious heritage and you cannot amend it so as to destroy its identity. This is due to the inherent limitation given in Article 368 itself, which says that constitution shall stand amended. And if the basic structure or the basic idea of the constitution can be amended, then which constitution will be amended and what will be the basic structure can be decided by us from time to time. So basically, the idea which I want to deliver is that when the government, by way of taking right of judicial review from the Honorable Supreme Court, the Honorable Supreme Court had taught a lesson to government also, कि no, you can change, but you can change only those things which cannot change the spirit of the constitution, which cannot change the basics of the Indian constitution. So in 368, in Madolkar, for the first time in his judgment, when he was delivering the judgment of Sajjan Singh versus State of Rajasthan, has said that there are something basic, which is basic in nature, but for the first time the word basic, the basic structure came into uses after the judgment of Keshav Nanda Bharti. So this by way of Sajjan Singh, Shankari Prasad, I.C. Golaknath and Keshav Nanda Bharti, what I want to deliver is that judicial review is one of the most basic structure, is one of the basic structure of the constitution. And when the government tried to took this right from the judiciary, from the constitution, then court came into picture and had given such decisions which change an era, because if the right of judicial review had been taken from Supreme Court, from the Honorable Supreme Court, and the government can do anything with had taken the right of do anything with fundamental rights, then it will also create problem for coming future, for coming generation. So this was the one part which I had deal about amendment procedure, about Sajjan Singh, Shankari Prasad. Now at very same time, in the decades of 70s, 1970s, between 1970 and 80, in 1973, after decision of Keshav Nanda Bharti, the Indira Gandhi government was in rule. So what happened in general election? One person, Raj Narayan, was contested an election against Mrs. Indira Gandhi, and Mrs. Indira Gandhi won that election. And what happened that after that, Raj Narayan had the constituent assembly, the constituent seat from where Mrs. Indira Gandhi contested the election was Rai Bareli. If I am not wrong, it was Rai Bareli only. From Rai Bareli, she had contested the election. And after the election, Mr. Raj Narayan challenged that election before the Allahabad High Court, Allahabad High Court. Now, Mr. Jagan Mohan has cancelled. Mr. Jagan Mohan has not on while deciding. Now again again this thing came into the court, into the hand of court, and the Honorable High Court not only invalidated the election of Mrs. Indira Gandhi, but also restrained her, barred her from holding the office of Prime Minister for next 6 years. And in aftermath of this judgment, what Indira Gandhi did is known to all, that Indira Gandhi proclaimed emergency under 352, under Article 352 of the Constitution. And many of the big leader from Bihar, Mr. Jayaprakash Narayan, had revolted against Indira Gandhi and the Congress government. Jayaprakash Narayan had told that what Indira Gandhi is doing is she is exploiting the machinery, she is exploiting the officers of the government of India, the machinery, to do work for herself, to do work for Indira Gandhi, and this can't be done in a democratic country like India. So due to this, what Indira Gandhi did, Indira Gandhi proclaimed emergency under Article 352 with assent of Justice with Fakhruddin Ali Ahmed. If I'm not wrong, Fakhruddin Ali Ahmed was the President of India at that point of time. So President of India had given assent for this presidential for this emergency under Article 352, national emergency. And after that, what happened? There was an act called MISA, Maintenance of Internal Security Act. Under MISA, the police had been provided with uncontrolled power to detain anyone. Now the detainees have no right, because as per emergency, all the fundamental rights were suspended. Now these detainees were in different states of the country, and they had filed a writ of habeas corpus in different high courts. Different high courts have different opinion. Some high courts held that no, the right to life under Article 21, and this habeas corpus right is always there, even there is an emergency. But some high court differed from this observation. So again the thing came into the arena of Supreme Court. Honorable Supreme Court, 5 judges bench, a constitutional bench sat in this matter. Mr. A.N. Ray was the Chief Justice of this country, and Mr. A.N. Ray in ADM Jabalpur case, in ADM Jabalpur case had given the majority decision. The court held that no person has any locus standi to move any writ petition under Article 226 before a high court for habeas corpus or any other court or any other writ or any order or direction to challenge the legality of an order of detention in view of presidential order dated 27th January 1975. Now here the problem arises. There is the Mr. I do not want to comment on the elevation of any justice, but Mr. Justice A.N. Ray had a past. Mr. Justice A.N. Ray was superseded by 3 judges by Mrs. Indira Gandhi. So the decision was not a surprise for everyone at that point of time, because elevation of Chief Justice Mr. A.N. Ray was done after superseding 3 judges. The 3 judges were senior from him, but they were not elevated as Chief Justice, and Mr. A.N. Ray was elevated as Chief Justice. So A.N. Ray had given a judgment, in favor of the government at that time. But Mr. H.R. Khanna, why I am why I am talking about this case here? Because there are some judges right now also in Supreme Court, and that point of time in Supreme Court, who showed their guts to save this constitution. H.R. Khanna, Justice H.R. Khanna was among one of them. He had given his dissent. He held that if the right to enforce Article 21 is suspended, then there would be no remedy against deprivation of a person's life or liberty by the state, even though such deprivation might be without the authority of law or even in flagrant violation of the provisions of law. So what Justice Khanna wants to say by his dissent, that if fundamental right under article right of personal liberty under article of personal liberty under Article 21 will be suspended, and in any case, then in that case, what will be the meaning of a society which are governed by some law? So what is the mindset of H.R. Khanna was that without sanctity of life and liberty, the distinction between a lawless society and one governed by laws would cease to have any meaning. So Justice H.R. Khanna, due to this, after this judgment, has to resign, had resigned from the post of Justice of Supreme Court, but he showed a way to coming generation that one has to say, and the judiciary has only the capability to say this: if the government is wrong, if the government wants to supersede the constitution, then only judiciary is the mechanism which can come between constitution and the government. Because what the constitution is just like a guardian of a family. If the members of the family can't support the guardian, then the value of guardian comes to an end in the family only. So if the constitution is the guardian of our family, then we the judiciary is that member of the family which will give respect to that guardian, which will take care of that guardian, so that the sanctity of the guardian, so that the respect of the guardian always be maintained by everyone. So government time to time tried to take that respect from constitution, but judiciary always tried to help the constitution, so that its sanctity be always be taken care of. So this is the era of emergency. There is a paucity of time, and there are many other things to deal. So I talked about Mr. Justice H.R. Khanna just to show I am also a lawyer, and I think most of the people which is hearing me will also become a lawyer and become judge of this country, become judge of the Supreme Court, judges of the High Court. So Justice H.R. Khanna showed us a path to walk to save the constitution. Another thing which another topic is Article 14, 19 and 21, which I want to deal. What happened in 1950, Mr. A.K. Gopalan, a person, a very landmark judgment, was A.K. Gopalan versus State of Madras. What happened? Mr. A.K. Gopalan was got arrested in this case, and when he challenged his arrest on the ground under that it is a violation of Article 21 as well as violation of Article 19, then what the Supreme Court held at that point of time in A.K. Gopalan versus State of Madhya Pradesh, in State of Madras, that Article 21, any fundamental right, not about Article 19 or 21 or anything, the court held that Article 22 and Article 23 gives power gives power to and procedure about the arrest of a person. So Article 22 and 23 or 21 or 19 can't be read together. So if you can't say that if Article 21 is violated, then you can see it in arena of Article 19 or 14, right to equality. But what happened in Maneka Gandhi case, the Supreme Court held that Article 14, 19 and 21, they all are connected. When it comes to talk about right to personal liberty of Article 21, if the right under Article 21 has been taken, then also we can see it under 14, 19 and 21. So interrelation of fundamental rights, which has been challenged in state, which has been challenged in state A.K. Gopalan versus State of Madras, was finally provided by the Honorable Supreme Court in Maneka Gandhi versus Union of India. They said that all rights are different. They said that all rights are different, but when it comes to save the basic needs of the citizens, basic needs of the person, then we can read it together. So this was the judgment of Maneka Gandhi versus Union of India. In Maneka Gandhi, if I can able to recall, if I am recalling right, the Supreme Court came with a very good observation that Article 14, which talks about right to equality, Article 19 about movement, or Article 21 about personal life and liberty, all of them are a stream of a river. All of them are streams of water. So if you can abridge one fundamental right or another fundamental right, then it will hamper the flow of the river. So Article 14, 19, 21 is a grand flow. So if we cannot interrelated these three rights together, 14, 19 and 21, the principle of golden triangle, what the court held it, the principle of golden triangle. So again, Supreme Court saved the soul of the Constitution, the fundamental rights provided under 14, 19 and 21. So this was about the golden triangle rule. After that, if I want to come, there is a right to privacy. In recent years, due to Aadhaar judgment, I think everyone came across this right to privacy thing. Right to privacy, the discussion and the discussion and the dispute is very old. What happened? There was a case, Kharak Singh versus State of Uttar Pradesh. What happened in that case? State of UP through a regulation, started monitoring the activity of a person named Kharak Singh. Now what happened? The Kharak Singh, when Kharak Singh came to visited market, then also police had an eye on Kharak Singh. In night time, police comes to house of Kharak Singh and knocked the door, and ask him you are at home or not, or ask his family members. So Kharak Singh has filed a petition, and after that Supreme Court in this matter in Kharak Singh decided that right to privacy includes two things: mental restraint and physical restraint. So in Kharak Singh, the Honorable Supreme Court, what the Honorable Supreme Court did, the Honorable Supreme Court struck down the regulation which were giving power to the UP police to put an eye on everyone, whoever they are suspecting. But the reason was not due to the reason of striking down the right to privacy was not the reason, was not due to was not right to enact the power of right to privacy, but it was due to the reason because that UP regulation was not maintained, was not backed by any law, any UP law. So they struck down the that regulation, but right to privacy was not become the was not become a right, or you can say a fundamental right under Article 21. So after Kharak Singh, again the government has the power, the government possesses the power to monitor anyone, to keep an eye on anyone. So this fundamental right, the again right to privacy was in question. And if if you have no right to privacy, then the existence of a human being will become invaluable. So again, Mr. Subbarao in Gobind Singh, Justice Subbarao in Gobind Singh held that no, the court can also see the stress of mental the position of mental restraint which is caused due to the action of government, not only the physical restraint. So in Gobind Singh, Honorable Justice Subbarao has held that a person also possesses the right to privacy, and no one can take right to privacy from a person under Article 21. And after that, Justice Puttaswamy in the year 2017 preferred the writ in Honorable Supreme Court about the Aadhaar thing, that the Aadhaar is taking the fundamental right of privacy. So in that case, the Supreme Court also held the Supreme Court held that yes, right to privacy is a fundamental right, and no fundamental right under Article 21, and no one can take this right from a citizen of this country. So again, Supreme Court, by virtue of judgment in Gobind Singh and in Puttaswamy, I'm so sorry. By virtue of this judgment, in these two cases, provided the Indian citizens with right to privacy. And among all these discussions, there are many things. There are many fundamental rights, such as fundamental right to education. Right against sexual harassment in Visakha case, right to travel abroad in Maneka Gandhi, right to dignity in Francis Collin, right to privacy in Kharak Singh, what I had discussed. And there are many other rights which were from time to time the Supreme Court has held that if the government tried to take the things from citizen or from anyone, which the Constitution has provided, then we are in picture, we can take care of this fact, and we will provide those rights to the countryman, to the citizen. So these are the things which I had dealt. I am so conclusively I can say only this.
Right, sir. Yes, indeed, it was insightful, and I would say that this part of
You are not
Constitution.
audible.
Am I audible now? Uh, am I audible?
You are not audible to.
Participants, am I audible to you all?
You are not audible.
Participants, can you hear me? Yes, sir. Participants can hear me. Am I audible to you, sir? Okay, participants, if anybody would be having any questions, so you can write in a chat box or in a Q&A. Okay. Could you please, sir, remove your earplugs? I guess there is some technical issue. Sir, can you see the chat box? The chat box. Uh, am I audible, sir, to you? Am I audible? Sir,
Yes.
you are audible to me.
Yes, now you are audible.
Okay. Yes, sir. So I was just saying, indeed, it was a very insightful session, and the portion which you shared with us, that is very important for be it a lawyer, for a students, that constitution part. Right, sir. We have one question from Vijay Kumar, and he's asking that why fundamental rights are there in the chapter 3? Why not in chapter 2?
Fundamental rights. Why fundamental rights in chapter 3? That question I'm so sorry to say, but why it is not in chapter 2? It is. I have no idea about this fact, so I'm so sorry.
Right. Okay, no problem. So we have another question from Vishwanath Das. He's asking that who is supreme, whether it's Parliament or Supreme Court, or is there any power to make rules by Supreme Court in directly or indirectly manner?
If I deal with this question, there is no question of supremacy of Parliament or the question of supremacy of Supreme Court. Because in Indian Constitution, as it is not directly deal about separation of power, but by virtue of some articles, it has been said that there is a silent separation of power between judiciary, executive, and the legislature. For example, if you can go through Article 122 and 212, validity, Article 122 and 212, and Article 121 and 211, you can see the difference. You can see the difference that there must be a separation between Parliament and the judiciary. If any proceeding which will go in Parliament, the judges cannot question about it. And if there is a proceeding or judicial conduct is going in Supreme Court or in any high court, the Parliament cannot discuss about it. So the question of supremacy, that the question of supremacy is not there. All are equals. There is separation of power. Not the express separation of power has been given in our constitution, but there is no one can enter into arena of one or other. But yes, they have the power to check each other. If the judiciary comes with certain things, which are not according to the constitution, then the parliament can struck it. And if the parliament comes with anything which is not according to the provisions of constitution, then also the judiciary holds the power. And most importantly, the judiciary can time to time the judiciary from time to time say legislature about the fact if the legislature is not doing what they have to do, and if doing something in extravagant manner. For example, the question what the sir has asked, Mr. Vishnath sir has asked about the supremacy, but in on that point I can just give the example of the law, the moratorium case which is going on in Supreme Court nowadays. In that case, what the Supreme Court and the government is trying, they both of them are trying to come with a solution, come with a thing which can help the citizen in most valuable manner. Not the Supreme Court has the power to say that no, you have to enforce the law of moratorium, and not the court has power, and not the legislature has power to say Supreme Court that no, we cannot come with moratorium or any other idea which can save the financial aspect, or which can protect the financial interest of the citizen. So the supremacy, it is very difficult to decide who is supreme, and in my point of view, no one is supreme.
Right, sir.
Yes.
Sir, we are getting one question from one attendee, anonymous attendee. Yes. That attendee is asking, why are the fundamental duties are not enforceable in court of law?
Fundamental duties or directive principles are not, because fundamental duties,
Maybe.
if I'm not
Yes,
wrong,
sir.
the directive principles maybe.
Directive
Yeah,
principle.
yeah. The directive principles, because the what I had said in starting about the things, the constitution came into force in 1950, and at that time directive principles of state policy were inserted in constitution. uh, all of us know that things in Indian constitution were borrowed from the constitution of different country. So if I'm not wrong, directive principles come from the constitution of Ireland, if I'm not wrong. So directive principles, they had been given there so that the government would try to reach to that goal. These directive principles are the goals which had decided by our constitution makers or the government at that time, at that point of time. So directive principles of state policy are the guidelines, are the things on which every government has tried to do, so that we will one day we will reach to that goal. For example, Article 44, Uniform Civil Code. So at that point of time, it was not possible that you can impose Uniform Civil Code and you can impose everyone to follow a same system. So they had given this Uniform Civil Code in article that one day, someday, when our country will become that much eligible that we can apply Uniform Civil Code all over the country, then that directive principle will be followed. So directive principle, and second thing is financial issues. There are many things in the active principles of a state policy which the government at that time can't do. So that is why it is not enforceable in the court of law.
Right, sir. Understood. Another question we are getting from Asha Jay Lakshmi, and she's basically asking your opinion. Like, sir, is it true that if Supreme Court did not interfere in creating basic structure doctrine, our democracy will turn to dictatorship?
This is also a difficult question to answer, because this will lead to me think about that condition which I had never faced, because as a lawyer, what I can say. But when we gone in past, when we visited the things happened in past, for example, the proclamation of emergency, for example, this is the only example which where we can see that the government may change into a dictator government. So I can say that the judiciary and the Supreme Court has always a role to play. Otherwise, the government may change into dictatorial government. It may be possible. It might be possible, in my view.
Right. Right. If any participant would like to ask any question from our speaker, they can also raise their hands. So we are getting one question from Prakash Kumar, and he's asking like, could you please tell like everybody reads all articles in the Constitution, like, like, or there any selective articles which we read?
First of all, I want to know that the person who is asking the question wants to become a lawyer or want to become a judge. If he wants to become a judge, then he must read all the articles. If he wants to become become a lawyer, then whenever the case will come to him, he will handle it accordingly. He will read that article accordingly. But this reply which I had given is on a lighter note. But read all articles if possible. If you have time, then read all articles. Otherwise, do one thing. Always try to read case laws, because if you are reading case laws, then you will automatically come across many articles which are useful for you in future. So try to try to make a habit of reading case laws rather than reading articles. Start reading case laws.
Right. Yes, understood. So we have one question from Jagannath, and he's asking, what's your view about the issue of Chief Minister of Andhra Pradesh and the Supreme Court of Judge? Recently, this case happened where
Yes,
Andhra
where
Pradesh.
Mr. N.V. Ramanna was in the letter written by Mr. Jagan Mohan Reddy.
Right, sir. So if you wanted to give your any sort of view on that.
The question is very good, but on a public platform, as I am practicing law in Supreme Court only, and I have to face Mr. Ramanna every day. So if the allegations which were put by Mr. Jagan Mohan Reddy has anything, any substance in it, then Mr. Ramanna also, Justice Ramanna also have to think about the same, why this kind of things had happened. The allegations on his daughter only. I read the letter, but not completely. But I read it. I came across that letter while reading something. So it's okay. He is a politician, Mr. Jagan Mohan Reddy, and Mr. Ramanna, and he has his own. He has own tussle. Mr. Jagan Mohan Reddy has his own tussle with Telugu Desam Party. So maybe it is a political thing. So commenting on it is not good for me as well.
Right, sir. No problem. We are taking two more questions. Then we'll sign off the session.
No
Mr. Vishwanath Das wanted to ask one question. He's asking why fundamental duties are non-obligatory in nature.
Fundamental duties are non-obligatory in nature. Fundamental duties are non-obligatory in nature because of one reason, and the reason is the diversity of our country. The diversity of our country. Why I'm saying this? Because at time of independence, again the same thing. At time of independence, many states were integrated at one platform and become due to Sardar Vallabhbhai Patel and non-obligatory, because if our country has no one national language, has not our country has different culture, our country possesses different things, so making it obligatory on each and everyone to do the same thing is really difficult. So that is why it is non-obligatory, but it has been given in constitution so that the person can take care of the fact that we have to do this accordingly, to take care of monuments. It is not, but now it is not obligatory. But you have to understand some if you can impose everything on citizen, then it becomes someday it becomes problematic for the country again. That is why I think that constitution and the makers of the constitution did not make it obligatory.
Right, sir. Understood. The situation which we discussed about the tussle between the Chief Minister of Andhra Pradesh and that case.
Mm.
So Jagannath is asking what is the role of Constitution that played into that particular thing. If you can please let us know.
The role of the constitution, the question of the constitution comes into picture is when the allegation against Mr. Ramanna will prove the allegations what has been alleged by Mr. Jagan Mohan Reddy will prove beyond reasonable doubt. Then there are many provision. There is provision of impeachment and everything in the constitution. But again, I can say that commenting on this thing
Right.
on a public platform where nothing is clear, nothing is.
Now things are vague and some things are not even clear, so it's okay, no problem, sir.
Yes.
Right. So participants, this was it. And now I'll request each one of you to kindly provide your feedback for this session in the chat box on the scale of 1 to 10, 1 being the lowest and 10 being the highest. Sir, in the end of the session, if you would like to say something, best way forward, then we'll sign off.
What can I say? I had said everything in starting. So if I can give an example, I can say that the constitution, whenever for law students or from my side, what is my opinion? I don't get your question. Anything for law students? Anything for the betterment of law
Right. So
students?
whatever we Yes, sir. For the law students, yes, for the law students and West way forward. Like many people think that the president is the true custodian of that of our Indian Constitution. On the contrary, today we have learned that judiciary is the true custodian. So please throw some light over that. And yes, best way forward and your views for law students who are preparing for judicial services. And yes,
Okay.
sir.
So. First of all, when I was a student in my college life, I had taken name of Mr. Kumar Kartikeya Tiwari. He was an excellent professor. He always taught me that a law student must need to make a habit to read the bare acts, bare text, and the case laws. Do not go to read the lengthy books and the voluminous books. And if you want to do something in your law career, start thinking things a lot. If you are reading something, sometimes when I and Kartikeya sir discussed, Kartikeya sir told that he had written that book. How can he read? He wrote that book. He must think about what he had written, because everything is given in bare act. Everything is given there in bare text. So you have to read bare act or bare text, then think about this, how the parliamentarian, how the lawmakers comes to the conclusion and wrote only these two lines about this law. Now on those two lines only, on those two sentences only, the judges think when any matter comes in front of him. So the judges then articulate their ideas only on basis of those two lines, those three lines given about the sections and articles in bare act. And so when you start thinking a lot, you will also able to write whatever the question, whatever the things comes before you in the examination. If you have idea of case laws, if you have idea of bare act, the wordings of section. So a law student must go for this. And constitution, what I have told about the what I have dealt about the custodian, judiciary as custodian. I had talked a lot. Maybe I was not able to deliver it in the best way, but
Right. No, sir. It was very good session, and you have cited important case laws, which are very important from the student's perspective, and everyone must know our history. Which
frankly speaking, this is my first class.
right,
In my whole life, I had taken a class for the first time. So
right.
I had the idea about the things, but delivering it in the best way, maybe at some point of time, uh,
Yeah, indeed, sir. But it was good session. We got to know a lot, and I believe that our participants would also had got something from this session, and we have received a good feedback from our participants. So now I'll sign off, and I'll sign off. And thank you, sir, for joining, and thank you for your important time to us.
thank you. Thanks.
Thank you, everyone. Stay home, stay safe. I'll